matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you with various law issues, and also to help you decide how to best protect yourself, your family, and your business. With information and resources, you may actually decide that you can handle some issues yourself, or at least you'll be better prepared to work with whatever professional you select. Our goal, of course, is to help you to achieve the best possible results while saving time and money. We, of course, want to welcome and thank once again Attorney David Bazar from the Bazar & Associates law firm in East Providence. He continues to help us with the various issues that we tackle. So today, business, starting a business, maybe buying a franchise, entrepreneurship, solopreneurship, as they say now in this gig economy, what you need to know, and even what you need to consider, pros and cons, tips and tricks, or not tricks. But okay, David, let's get started. I don't know if I want to ask you first about freelancers, but there are so many of them in what's called this gig economy. The number is something like 16.5 million people now who have alternative work arrangements. When does a freelancer have to decide to go official, make it official? And how do you do that?
Most freelancers, as you're talking about, are probably, in many instances, 1099 independent contractors who work for one particular company. And if that's the case, you probably do not have to form a business yet, although I always advise that you do, because you have liability protection. And so if you have a business that you're working on your own and you're consulting with more than one company and you're really not just an independent contractor to one company, then it's probably a good idea to form some type of business entity to give you some protection. And
apparently there are many who do one service and they collaborate with others, perhaps in the same city, state, town, or at least in the same country. So if they're just collaborating loosely, do they need to formalize that? Is there any reason that they have to when they have independent pieces of a bigger piece of a puzzle?
It actually is always a good idea to have some kind of agreement or contract in place to determine what you're doing, what your role is, what your responsibilities are, and what is your share in the outcome of whatever is created together.
I imagine that is not a do-it-yourself issue, but let's talk about that. So let's talk about business structure. There are four, I guess, primary forms of them. What are the components of each, and how do you have to consider, what are the factors that you consider? Let's go over that a bit.
Sure. So there are different types of ways people can organize to do business together or alone. And most commonly there's corporations, which can also take different forms. In terms of taxation, it's a subchapter S corporation or a C corporation, those types of things. The advantage of a corporation is it gives limited liability to the stockholders, which are the owners of a corporation. There are some limitations and disadvantages in some degrees, but it depends on what you're trying to accomplish. If you're looking to form a corporation where you're going to have investors and you want to bring in outside investors or stockholders and give them absolute immunity from any wrongdoing of the corporation, it's usually a good entity. But here's what happens with the formation of any business. The client comes into the lawyer and says, I want to form a business, I want protection, and I want to know which one to form. And then the lawyer says, well, you need to talk to your accountant to find out from a tax perspective what's the best one to do. Then the accountant says, well, you really need to talk to the lawyer. So what we end up having to do is getting on a conference call or meeting all together and going through the pros and cons of each type of entity.
Sounds good. How about the smallest entity? Someone who says, I'm just a sole proprietor. I can stay doing this for the rest of my life. I don't really have a very big overhead that way. I'm not employing anybody right now. Can I just stay like that, David? What would you say to that?
We would recommend a limited liability company, commonly called an LLC, which there's a number of different taxation ways of forming that company. It can be a sole proprietorship, which is disregard the entity from the owner so that the taxes and tax issues can flow directly to the owner. There can be a partnership arrangement, so if there's more than one, it can be taxed as a partnership or it can be taxed as a company.
So when people think about size and scope, I guess whether it's the accountant or the lawyer, that's a very big issue or bridge to cross first. If someone knows that they want to be big and big quickly, you're, I imagine, going to go for be an incorporated entity because the bigger you are, the bigger your risk and liability wherever. Is that a pretty basic consideration?
There is some truth to that. An LLC in many instances could be an entity that's used, but if there's going to be multiple members and the operating agreement's going to be complex, sometimes it may be better to go in the direction of the corporation so that there can be stock offerings if that's the type of business plan that the person forming the corporation might have.
Another factor, as I understand it, is the amount of control you wish to keep or surrender. So if you're a sole proprietor, you are it. The buck stops with you, so does the risk and the liability, but you have complete control. How much control do you, on the other hand, lose versus what do you gain by going that route?
Right. So in an operating agreement of an LLC where there's going to be more than one member, the members spell out who has control. Is the LLC managed by a manager or the members? What are their rights and responsibilities? And so that can be all spelled out. And you can potentially lose some control if it's a manager type of LLC and the election of the manager is controlled by the members and their voting interests, and you now no longer have control and other members have decided we want a different manager. A corporate structure, which is the structure of separating ownership, management, and government, so to speak, of the corporation, is more interesting in that the owners elect the board of directors. So the owners are the stockholders. They elect the board of directors. The board of directors hire the CEO, the COO, the managers or management of the company. And so if you think about corporations like that in terms of the New York Stock Exchange, for example, we invest in those companies. We have a vote, depending on how many shares we have, it's a very small vote, to elect the board of directors. The board of directors then hire the CEO and have control over the management, and the management has control over the direction of the company.
Sounds right. Most small businesses will, if they're thinking about or putting their toe in the water about incorporating their business, one of the first things that we typically hear when we're doing business consulting is, well, I better incorporate because then I am forever protected from a lawsuit. I am no longer personally vulnerable. True, false? Not.
There is some truth to what you're saying, but there's also this notion in the law of piercing the corporate veil. Mm-hmm. And so if a company is formed and it's undercapitalized and you're using it as really an alter ego of yourself, there's a possibility that somebody who's going to sue the company is saying that's really not an entity that stands on its own, but it's really you, and they pierce that corporate veil to get at you personally for liability. There's rules on how that can happen. It's not, if you do it right, it's not easy to have the corporate veil pierced, but you have to make sure you follow the rules of corporations and don't act out ultra vires, I guess is what we call it, outside of what you're allowed to do in the scope of a corporation.
If you were part of a corporation and someone misbehaved, had a breach of a contract that you didn't even know about, or had somehow been neglectful of their fiduciary responsibilities, did something wrong with the money, are the rest of the board are they liable? Stockholders, rather, are they liable or are they protected?
So it's one of the reasons I generally favor using a corporation structure or LLC, but certainly a corporation structure rather than a partnership, Because in a general partnership, and there are many, many forms of partnership, and we didn't really touch on those, but in a general partnership, all the partners are liable and responsible for the activities and actions of the other partners. In a corporation, if somebody acts outside of their scope and you didn't know about it, have any reason to know about it, and there's other layers of protection, then you are protected for what somebody did wrong under those circumstances, other than if they were acting in the scope of their employment with the corporation, that the corporation might be liable for what they did under the theory of respondeat superior. They work for the corporation is their master, so to speak. The corporation could be responsible for their actions, but not the other stockholders.
Good to know. Before we get into the drill down of each of those entities, when someone's starting a business and they want to talk to you about their potential or expected profit, obviously everyone who starts a business wants a profit. Do you ever use the anticipated profit as a gauge for whether they should be incorporated or have it as a partnership? Does that impact on it at all, the money expected or the profit expected?
Well, certainly from a tax perspective.
Yes, that's why I'm asking.
When
yes.
you're picking the entity you want to use, that would be a factor that would go in. If there's a startup company and we're anticipating that very shortly it's going to be very profitable, you want to certainly bring your accountant in and say, what's the best tax entity to use for this as we start? If you're anticipating losses, again, you want to go back to the accountant and say, what's the best entity to use so we can pass through losses and shelter some income from other sources if there is any? Those, for me, are accountant questions as we decide which form of business to use, which type of entity. But I would always tell you that there are so many different ways of starting a company that is one of the aspects you should look at in terms of what type of entity to use because of the taxation, but it's only one of the issues to look at.
When you're talking about money also, some businesses are fine bootstrapping. They took some money out of savings or whatever. But if they are looking to grow and think that they might need capital, does it make sense to say that, or would you agree, sole proprietorship would likely have more difficulty raising money than a bona fide corporation? How does that work?
Well, as a sole proprietorship, you're not going to raise money by selling equity interest in your business because there's nothing to sell. Mm-hmm. The only way you're going to raise money is through loans, probably. Mm-hmm. If you're looking to bring in equity, you have to have something to sell. So there either has to be stock or a membership interest in an LLC or a partnership interest in a partnership. So depending on how many people you're looking to bring in or raise money from, that will also have an impact on which type of entity you choose.
Okay, and while we aren't talking about divorce in this segment, if you're a sole proprietorship, you decide to close your business, you decide to close your business. Once you've entered into corporations, partnerships, and the rest that we're about to get into, what happens when there is suddenly no longer love? When you're starting the business and there is likely to be a dissolution at some point, or there could be, what are the pros and cons of having a partnership versus a corporation?
Are we talking about a divorce amongst the owners of the business?
Yes.
Or a divorce for one of the owners of the business?
Oh, why don't you explore both?
Okay. So, Chris, they are different.
Yes.
So the owners have complete harmony, and there's 3 or 4 or 5 coming in. And the way a business is dissolved is either through agreement of the partners, or in Rhode Island, a receivership could be filed or that type of action taken, so that if there's no clear majority of owners deciding which direction to go in, or if the minority is being frozen out, there are some legal actions you can take to dissolve a corporation. An LLC has certain rules that you would write into the operating agreement to determine how you're going to go about doing that. And a partnership could have a partnership agreement that would also decide how to do it. So the dissolution of the business amongst the owners of the business wouldn't be the primary driver for me to determine which entity I was going to pick. But in forming that entity, I certainly would build in what we're going to do in the event of a dissolution. So whether it's an operating agreement, a partnership agreement, the bylaws and corporate structure of a corporation, you want to have all of those things considered when you're forming the business.
A good business plan should have an exit strategy too.
Absolutely.
Whatever you're going to be doing. So let's talk about the partnerships and the corporation structure. There are variations under those larger banners.
Correct.
Want to break them down a little bit?
Well, for partnerships, you could have a general partnership, which we spoke about a little bit, where each partner is equally responsible for running the partnership, has an equal voice and also an equal responsibility, where you're responsible for running the business, but also for what your other partners do. There's a limited partnership, or LLP, even limited liability partnership. Limited partnerships may have a general partner and then limited partners who don't have any control over how the partnership is run and whose liability may be limited, therefore, against what the general partner does. Go ahead.
And did they have a distinction too, so that if there's a lawsuit that the business is separate in the individual is separate from the business in terms of their vulnerability?
In a limited partnership, there is some limited liability of the partner. Oftentimes, what we find, if you do it correctly, you're limited to the amount of your investment
you put in.
Exactly.
Okay. And the other that we were going to talk about?
So we talked about general partnerships, limited partnerships. There, I think you wanted to talk about
corporations too,
as well.
S's and C's.
Right. So a subchapter S corporation allows the taxes to be passed directly to the shareholders, and the shareholders can then either take the deduction if there's a loss on their taxes individually, or report the income directly on their own personal tax returns. A C corporation is what used to be called a double taxation corporation.
Yes.
Because the corporation itself files a tax return, and that tax return on profits that has a corporate tax that's imposed, which was reduced actually under the tax reforms that President Trump had put in at the beginning of his term. And then if dividends are paid out to the shareholders, which is how profit is passed through a C chapter corporation, chapter C. The dividends are then taxed as well at the stockholder level. So your profits are taxed and then the dividends are taxed, which is why they called it double taxation. But you need to speak to an accountant with the change in tax structure and tax rates for a C corporation. Some of the benefits that you receive by doing a subchapter S corporation may not be as great as you get with a C. So there's a lot of different things to look at, and it's at a grade level far above my pay level for taxation.
So this also is sort of in the accountancy camp, but if you wanted to take a paycheck, if you're a sole proprietor, you might just take what funds are available. If you are an LLC or a corporation, must you have a payroll of at least the owners?
No matter what structure you have with employees, you have to have some payroll structure to make sure you're deducting the proper payroll taxes and paying your taxes that are on a payroll and that type of thing. With a corporate structure, you get the benefit, whether it's LLC or otherwise, of having some retirement planning that can be put in place. And there are different plans that are allowed to be done by different entities, as opposed to a sole proprietor who might be limited in what type of retirement structure he can put in for his benefit and his employee benefits. And again, I know enough just to tell you that you need to look at that, but you want details, that's again beyond my
Check
payroll.
With the accountant.
Yeah, pay level.
So in addition to the business structure, when someone wants to start a business, let's just talk briefly about what are the licenses or permits they might need. Care to address that?
So when you start your business, depending on what type of business it is, there are certainly different things that you have to do. So for lawyers, when we start a business as a law firm, we have to register with the Supreme Court for our entity that we're registering. You have to file with corporations to determine what type of corporation you're filing. You have to have your malpractice insurance in place so that that can be filed with your registration in your corporate filings. And you have to be licensed to practice law. Plumbers have to be licensed to be plumbers, and then you have to have different registrations and so forth when you form those businesses. And if you're going to have a retail store, you have to have a permit to make retail sales. You have to have a sales tax form and all the other types of registrations, local and statewide, that you need to have.
And while we might need a lawyer, we might need an accountant, suffice it to say that every state has its own laws, its own regulations, but
Right.
you can easily find out a little bit more about what those are on the state government sites.
Sure.
They'll let you know about what forms you need to fill out.
And if you're starting with a corporate structure, the Secretary of State's website has all sorts of advice on how to start a business and what you need to look at and know.
In a zoning situation, you're a small business, sole proprietor or not, where do you find out what you need to do in the town of East Greenwich, or the city of East Greenwich versus
Town of
Johnson?
East Greenwich, city of East Providence.
Yes. Where do you find that out?
So certainly city or town hall is always a good starting point.
Clerk's office, right?
Clerk's office.
Sounds right.
And if you're looking at zoning, then you must be looking because you're either going to buy or rent a place to do business. If you're looking to do business out of your home, you have to know what rules apply to doing business in a residential zone. So certainly that's a good starting place.
Okay. Those who want to look at doing a business, startup business that's already established, they might buy a business, and I assume that needs a lawyer. What about buying a franchise, which often could be fraught? We could probably do a segment on that alone.
Yeah.
But what are the main issues for someone to look at when they're thinking about purchasing a franchise?
So I've done a number of representation of franchisees buying franchises. Many times people are buying them from existing franchisee owners and they're looking to transfer it. So there's a lot of things you have to look at. First and foremost, you want to go in and look at what type of business they're doing, what do the books show, what kind of profit is there. Then are they leasing the property that they're in, and does the lease coincide with the length of time left on the franchise agreement? What are the terms of the franchise agreement? There are so many different things that need to go into that you need to hire an attorney to go through all of those types of things with you as you're looking to decide whether or not you want to buy a particular franchise.
For one other example that I'm familiar with, the franchisor would have, for example, an advertising plan in place. He'd probably write that up in his documentation in trying to pitch the would-be franchisee. How would you ever know whether or not what he says he's going to spend is being spent as an average person considering all of these variables that he's claiming to make? How would he know?
The franchisor has a lot of documents that they have to give to somebody who wants to buy a franchise. And in those documents, there's disclosures that need to be made. And that's where you start. But I think the inquiry needs to go a little bit beyond that. If I were buying a particular franchise, I might contact owners of other franchisees and ask them what their experience has been, and just try to get some honest feedback from other people so that you know, if I'm going to buy franchise X, do they do what they say they're going to do? Is this stuff that's in the disclosure forms I'm looking at correct? And how has your experience been in dealing with them?
What about, again, not the divorce per se, but that exit strategy when it comes to you buying into a franchise? I would imagine that also can be fraught. What do you look for? What are the red flags?
So in the franchise documents that you're going to be asked to sign, there's going to be an assignment or transfer of your franchise if you're looking to sell it to someone else. What rights are retained by the franchisor over being able to stop you from transferring the franchise? What will they require? Do they have the right to approve whoever's buying your franchise? So they have a right of first refusal, meaning they can match whatever you're getting for the franchise and buy it themselves. So those are things that you really need to explore with an attorney as you're looking at, I want to buy this franchise, but what if I want to sell it? Am I able to do that? Am I limited in my ability to sell? Am I limited in my ability to bring in other investors into the franchise?
Good point.
So all of those types of things are in those documents, and you need to know what you're looking at.
So when they present this package to you as the potential franchisee, everything is set in black and white, and say someone is working with a lawyer who's going to peruse those documents. Is everything really in black and white, or do you have some leeway to negotiate, and do you often find the place to do that? Is that one of your jobs as an attorney for that person?
It depends on who the franchisor is, how big they are, and how much they're willing to do. I've not done a McDonald's franchise, so we'll use McDonald's. I would imagine that trying to get McDonald's to change the terms of their franchise is really difficult. Maybe if you're buying 100 of them, you might have some leverage, but if you're buying one, I would assume that the lawyer can try all he wants to change some of the terms, but they're probably not changing. As opposed to a smaller franchise, maybe a company that has 10 or 15 or 20 franchises, you might be able to get them to agree to negotiate some terms, and sometimes that's really important to do.
Good to know.
Yeah. And so is it in black and white? The black and white is really important in your franchise agreement, and you need to go through, and sometimes they're really thick, but you need to go through and understand what's on each page.
With the limited amount of time we have left, could you just briefly address the issue about the leases? So often a franchisor says, I have the lease, you're taking my lease. Do you want that? Is it better if they have their own? Should they have that alternative? What do you think about that?
It comes up in a number of different ways. The franchisor may own the real estate and is assigning a lease to you or creating a lease with you. You may be taking over a lease with a third-party landlord, and that's what I was talking about at the beginning. Does that lease match up to the franchise agreement? So are you buying a franchise agreement that has 10 years left on it, but the lease only has 5, and then it has to be renegotiated? You need to do that, and perhaps my advice would be you want it renegotiated at the beginning so that the option periods on the franchise agreement match up to the option periods on the lease.
Seems like it's very worthwhile to spend that time in advance going through every single line rather than trying to argue about it on the other side of it. Do you often end up with that as much as you do the ones that are just starting out?
Both.
You
yes.
do?
Yeah, and they can be difficult, and you just need to hope that the franchisor you're dealing with will be reasonable so that you can resolve whatever misunderstandings or differences there are.
Do you find that the franchisors often are likely to breach their contracts on their side, or the franchisees? Do you find much of that?
I find that sometimes, and depends on the franchisor, there can be differences of opinion on what the responsibilities are and what you're doing and what their role is versus your franchisee's role, and sometimes you have to bridge that gap. And
that's a drill down too, I would imagine. Again, is that something that you vet line by line and discuss with your client?
Depending on the situation, yes, but sometimes there are things that come up afterwards that are just in the operation that aren't really contained specifically in the franchise agreement, and it's really, there's something in there, but we're looking at it one way, they're looking at it another.
Good to know. We hope that this has been helpful to you if you are starting a business, buying a franchise, or just going out on your own as solopreneur. We thank you for tuning in to The Law Matters. We hope you'll continue to do so because the law matters to you.